Before us today. I want to thank you for holding the hearing, and especially your staff. In a Congress that is often divided on partisan issues, this is a unique committee. The staffs work parallel. We actually compromise. We worked to find common ground to solve real problems. Without Chairman Levin's support, we would not have been able to undertake this investigation. We're here to discuss this report, which really looks at how Social Security approves claims for both the SSDI and SSI systems. Both of those are critical promises to people in our country that have, not through their own means, acquired disabilities that requires that they can no longer achieve what they would like to achieve on their own through their own means. The Congressional Budget Office has been clear that the disability programs are teetering on bankruptcy. If you actually look at their recommendations over the last 5 years, you see we're coming closer and closer and closer. We're losing a year almost every year in terms of the time of insolvency. The Social Security trustees have concluded that the disability insurance program may go bankrupt in 2015, and that's because the rolls have grown faster than anticipated. That's completely understandable given our financial experience over the past 4 years in this country, and the fact that people who were truly disabled were still working because they had the benefits and the wherewithal to continue to do that. Losing health insurance through layoffs is one of the reasons that people who were disabled but were still working have increased in the number of applications. Since January 2009, Social Security Administration has added 5.9 million Americans to the disability rolls. That's about 78,000 per month. That's 14,000 more added to the disability rolls than we actually created in terms of jobs. With the trust funds approaching insolvency and the law saying that the funds to provide SSDI come from the revenues that come into SSDI, Congress is handicapped in terms of supplementing that, which means that anyone who's collecting disability that shouldn't be collecting disability will ultimately be taking funds from those people who actually deserve disability once the trust fund reaches its insolvent point. Millions of our neighbors depend on these programs to replace a portion of their income they earned before they became disabled. For many of them, this is a lifeline, without which they would be absolutely overwhelmed. For the past 18 months, this subcommittee has conducted a bipartisan investigation into how well the Social Security Administration is running these programs. Our hope is that where we find problems, we might also offer solutions. We decided to take a look at a random selection of 300 case files, all of which came from 3 counties and represented a broad mix of disability applicants. We carefully chose 3 areas of the country that had different concentrations of people receiving disability benefits, from a very high to a very low to a mid-range. We worked closely with the Social Security Administration to develop a methodology that would give meaningful results. One of the places we looked was Oklahoma City, my home state. It was and is my firm belief that if Congress is going to get serious about reforming our government, oversight must start at home. Unfortunately, some of the worst problems we saw were in my home state. The good news is that Oklahoma is also home to a disability success story. The Oklahoma Department of Rehabilitative Services is helping set individuals on disability back into the workforce to become productive, self-sufficient Americans. One individual there, Jason Price, developed a system for giving monetary incentives to vocational rehabilitation counselors who found work for disability recipients through the Ticket to Work program. thousands of people who were disabled are now working in Oklahoma, and nearly 1,100 of those no longer are on SSDI. In 2010 alone, Price's initiatives resulted in 135 individuals who were severely disabled going back to work, ending their dependency on disability payments. The state recouped over $2.3 million. I'm proud of his work, and I hope his example will be shown to other states to see how to get even the very severely disabled back into the workforce. And let me tell you why that's important. When somebody is deemed disabled and we help them through the Social Security disability system, we're actually accomplishing one of the intents that we intend to. Our compassion becomes real. When somebody collects disability that's not truly disabled, we actually harm them. We limit their potential. We limit their ability to go through a program like Jason Price has developed, to actually give them real meaning and to perceive their real worth in our society. To understand the problems we uncovered, it's important to explain how someone gets disability benefits. The first step is that a person applies at his or her Social Security office. They're eligible for benefits starting the day their disability began, not simply on the date that they made application. To support their claim, they can submit medical records if they have them. If they do not have medical records, the agency, the Social Security Administration, will pay for them to get a consultative exam. This forms the basis for SSA's basis of evaluating someone's initial claim. The local office does not make the initial decisions. Rather, this is done at the state level of the Disability Determination Service, or DDS. There's one DDS in every state. And that's where nearly 2.5 million applications are first dealt with each year. 33 to 35% of those applications are approved. If it's denied at the DDS level, a person can ask for have a second set of doctors take a second look, called a reconsideration. If it's denied again, the person can appeal once more to request a hearing before an administrative law judge. And that's the point that Senator Levin made. That's where our big backup is at the appeals, at the administrative law judge level. At this level, a claimant's case is supposed to get a fresh review by an impartial judge who has independence to decide cases on their merits and the record. They are not bound by any prior DDS decisions. Social Security has over 1,300 administrative law judges who handle 700,000 appeals they get each year. I'm thankful to the Social Security Administration for the chart they sent us last night listing receipts of applications, receipts for reconsideration, hearings, and appeals, as well as federal court. And what it shows is the tremendous increase that we've seen and the burden placed on those people working at Social Security through the financial consequences of the recession that we've been in, and a significant increase in the workload for the employees that work at Social Security Administration. The questions that I really have, which concern me the most, is that the initial approval rate is between 33 and 37% at the initial determination rate. Of that percentage, up on reconsideration, about 14% approval rate, which figures out to be about a 3% approval rating based on the total number that were denied. So through the Social Security, before you ever get to an administrative law judge, we've essentially approved about 36 to 40% of those people who apply for disability. And these are professionals who do this, who work for the Social Security Administration. They understand this is not a simple system. It's a complex system. And in my mind, they do a very good job. However, each year, approximately 600,000 to 700,000 claimants file for a hearing in front of an administrative law judge. And on average, of those that are heard, about 61% are approved. So the real question that I have is, here's the professionals in Social Security Administration who are taking the record, taking the facts, and making a determination. And 61% of the time, the administrative law judge disagrees with the professionals at Social Security Administration. So one of two things is happening. Either we're not getting it right at the Social Security Administration by the people who work these records, know these records the most, or we're not getting it right at the administrative law judge level. And the other question that the committee has not looked at yet is who are the number of people who have been denied that should have gotten Social Security disability payments? So I hope that as we go through our hearing today, that we can gain some better understanding for why the professionals at Social Security are so often countered by the administrative law judge. One of the two is not working well to increase that level, and that's a question that has to be determined by this hearing. We need to know the answer to that. Let me continue on my survey. If an administrative law judge denies a case, a claimant can appeal to the Social Security Appeals Council, and anything unresolved after that, they can go to federal court. There's another problem, is we have different standards on appeal by each appellate division. So a federal judge or magistrate in Oklahoma City looks at his district precedents, which are different than maybe the Second Circuit precedents. So we actually, at the federal court level, have a different set of standards based on precedents for who becomes qualified and who doesn't. And I think that, Mr. Chairman, we haven't had a chance to discuss that. Pardon me, is something that should be uniform throughout the country. It needs to be the same everywhere, not different in any of the different 10 circuits. The results of our inquiry, to me, were deeply troubling, and I think Social Security is right on top of this. They essentially found the same thing we did. What we found was poor quality decisions being made about cases at every level of review. Over and again, this investigation found the Social Security Administration failed to follow its own program rules and procedures. The importance of Social Security getting decisions right can't be overstated. Moreover, the agency rarely checks to see if a person's condition improves. While it is supposed to perform consulting disability reviews, what in actuality happens is what the agency does in terms of continuing disability review is sends out a card and asks the question, are you still disabled? That is not a review. And I understand the budget constraints and the difficulties with those continuing disability reviews. Overall, the subcommittee in its investigation found serious flaws in more of a quarter of the 300 cases that we reviewed. That's not to say that they were in error in terms of their ultimate decision, or that they were right in terms of their ultimate decision. What we found is that they weren't following the rules. They weren't looking at the evidence. And if I may, I'd like to put up this one. The top ALJ errors that we discovered: inadequate physical examinations, inadequate mental evaluations, claimant credibility issues, drug and alcohol abuse that was unexplained, and incomplete and inaccurate records, which I would note for the bottom is probably the most important aspect. It ought to be complete and it ought to be accurate if it's coming from an administrative law judge. It ought to be complete and it ought to be accurate. The most concerning findings involved decisions made by a few of the agency's administrative law judges. This was consistent with a review that you all have done. In 2011, the Social Security Administration's Appeals Council found a 22% error rate in cases it reviewed that were made by ALJs. In the Dallas region, which Oklahoma City is part of, the ALJ rate was over 26%. The kind of problems we found with ALJ cases were both numerous and troubling. There was conflicting data, missing and insufficient evidence to make a determination according to their own guidelines and their own rules. Oftentimes, medical evidence was ignored, not looked at all, not considered at all. Second, many judges held perfunctory hearings at which claimants didn't even say a word, despite involving some of the most complicated of cases. Some hearings lasted only 3 minutes, leaving barely enough time to gavel in and gavel out. A third problem involved judges using late arriving evidence, which the agency discourages. Some ALJs raised red flags about what they called dead man reports and store-bought opinions. Fourth, some ALJs would ask vocational experts leading questions that could only give one answer. That is not on the basis of fairness and getting to the truth. That's to try to get a result. While the Social Security Administration officials that were interviewed by the subcommittee acknowledged that all of these were significant problems, they said there was little they could do about it because by law, administrative law judges are given a lot of independence to make their decisions. The result is a tension between the agency's ability to control the quantity and the quality of the judge's work. Many people we interviewed said this tension was evident in how Social Security Administration tried to reduce its enormous disability case backlog. Nearly everyone we talked to said there was enormous pressure on judges to push through as many cases as possible. In May 2007, Commissioner Michael Astrew told Congress that he would end the growing wait time for administrative law judge hearing. To reduce this wait time, the agency encouraged judges, where appropriate, to consider skipping hearings and write decisions on the record. One judge we encountered in our investigation played a big role in this effort. Between 2000 and 2009, administrative law judge from Oklahoma City office singly handled 5,401 cases, almost all of them on record and without a hearing. His decision rate was 4 times faster than the average judges. First, I was astounded that somebody could decide 1,800 cases a year, especially since, on average, they're 500 pages long. I'm a speed reader. I'm a fast reader. There's no way I could have done that, ingested that information, and made a decision on it. I still have questions on how that was possible. On average, he decided 5 cases a day, 365 days a year for 3 years. I soon learned that he could move through them so quickly because the quality of his work left so much to be desired. Unlike the other ALJs, he simply cut and pasted electronic images of medical evidence into his decisions. To speed up the process even more, instead of specifically listing and discussing all of a claimant's medical impairments, he would write, et cetera, et cetera, et cetera. Worse still, the images that were pasted into the opinions would sometimes have nothing to do with the person's claim for disability. In several cases, the records he pasted said the opposite of his findings. For example, in one case, he found somebody could no longer work, but pasted in a medical record that concluded the claimant can adapt to a work situation. The basis for his decision was exactly opposite of the decision that he granted. He was eventually asked by the agency to improve his decision writing, but instead of reducing his caseload to a manageable level, the agency began shipping him cases from around the nation. He told us that at one point he was asked to do 500 cases just from Little Rock. On average, an average judge's caseload for an entire year. When he finished those, he was sent cases from Atlanta, Houston, Greenville, Des Moines, and Yakima. Why the Social Security Administration did that is a question I'd love to have answered today. I know the pressure was to decrease the backload. The question is with what quality and with what outcome? Who was denied that should have gotten disability? Who got disability that shouldn't? The problems we found, however, were not limited to administrative law judges. The subcommittee also identified a number of issues with the cases the state disability determination services were making at both the initial and reconsideration levels as well. One of the biggest problems was how the agency uses its medical vocational rules. This complex set of rules, known as the grids, are for people who do not qualify under the more difficult medical listings, but still might be truly disabled. The grid contains a variety of factors such as a person's age, education, and work experience, laid out in a large set of charts. Depending on whether a claimant can perform sedentary, light, medium, or heavy work, agency decision makers can use the charts to find out whether someone is disabled or not disabled. Finding someone disabled this way is referred to in the agency as gridding. While most disability awards were at one time made to people who met medical listings, today it's the opposite. The ratio is now 4-to-1 gridding versus a medical determination. A recent analysis by the agency found that ALJs awarded benefits through the vocational grids 4 times more often than through medical diagnoses. Another problem is that the grids are easily skirted. Frequently, the subcommittee found that even though if the grid found someone not disabled, ALJs would overrule it and award disability benefits anyway. The most frequently seen problems involved the use of a claimant's age. The grids relax the rules for claimants once they turn 50 and then again at 55, appropriately so, making it progressively easier for applicants to be accepted when they hit these ages. And we all understand that. That's understandable and logical. In a lot of cases, the grids found someone was too young when their ailment started, and so they were not disabled. The ALJs then would adjust the change in the disability onset date to the claimant's 50th or 55th birthday. By doing so, the claimant now qualified under the grids. Nothing indicated the person was more disabled on their 50th birthday than they were the day before. Conclusion is the purpose of this program is to make sure that all of our citizens who are truly disabled, we help, and that the safety net be secure. It should be remembered, though, that by the law, by the statute, being disabled means being unable to work in any job in the national economy. This is a high bar to meet. The agency must make sure it is awarding benefits to the people who are entitled to them. If something doesn't change and the programs continue to operate the way they are today, there will not be a safety net left. The trust fund will be out of money. And those that are truly disabled will see a reduction in the payments of their benefits. So if, in fact, we're accurate to this point, means that Congress has to do something to increase the funding for these programs, either through increasing the tax rates that apply to them or changing the definitions. We can start by putting, and I know my chairman disagrees with this, but we can start by putting somebody representing the taxpayer in one of these hearings. And just having them there will change ALJ behavior. Somebody else who knows all the record. And my real worry, Mr. Chairman, as we looked at this, is that the record wasn't thoroughly reviewed, oftentimes, in many of the 300 cases that we looked at. And having somebody in the room that will force the ALJs to truly look at the whole record will make a big difference in the quality of the decisions and also the rules by which they make those decisions. I also would note that this is supported by the ALJs themselves and their union. It's been a long time standing recommendation of the Social Security Advisory Board, the bipartisan board created to advise both the President and Congress of the changes needed to the agency's program. Other simple changes would go a long way as well. The evidentiary record should close at least 1 week before the ALJ hearing to give the ALJ the opportunity to judge that information in light of the whole record. Late evidence would simply mean rescheduling. It wouldn't mean the evidence wouldn't be considered. The vocational grids must be eliminated or reformed so that someone who is 50 years or older is no longer approaching advanced age in the United States. These and other reforms outlined in today's report, I believe, are at a minimum what should be considered by Congress if we're to, in fact, continue what our ultimate goal is to truly help those people who have become disabled with their life skills and their income as they mature. Mr. Chairman, again, I thank you for this hearing. I look forward to the testimony of our witnesses.
Well, again, thank you, Dr. Coburn, for this thorough report of the report.